All right, you should be good to go, Davis.
All right, well, I'll read the ethics statement, then we can get started. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest.
Well done.
Yeah, thank you. Right, I'll let you start off with kind of your thoughts, and then we can go from there.
Yeah, so you all have the oh, and here comes Takia. So we've got the whole band together. So this grievance inquiry came from, of course, the grievance committee. They were looking at a situation where, in connection with one of the grievance files, there was a fee agreement that was turned in, I guess, as part of the investigation, and the fee agreement contained this clause that you see in both the memorandum from Kevin Williams, who was the chair of the grievance committee at the time, as well as in the proposed opinion. And really it focuses on the notion that a billing rate charged to the client can be changed during the course of the representation. And this particular clause said at least once each calendar year, the billing rates of all firm employees are reviewed and may be increased. Client will be notified on the client's billing statement when these billing rates occur, or rate changes occur. And so the effect of it was, of course, the client experienced an increase. They received a bill at some point over maybe the first year of the representation, and there was suddenly a fee increase. It was a rate increase, just as stated in the fee agreement. Client, however, was not given any sort of I guess immediate notice. You can say they had notice. They were told in advance that there was going to be some sort of rate increase, but they weren't told exactly when it was going to occur. They just suddenly got a bill and there's a new increase in the rate. Client was expected to pay that new rate, and it was already applied to work that had taken place that was reflected in that particular invoice. And so the question that Grievance sent over was, is this type of thing permissible? And in particular, we have, I feel like it's important to point out that we have a difference in our rules compared to the model rules. 1.5 in North Carolina has a comment that really kind of focuses in on this notion of once a fee agreement is reached between the attorney and the client. This is comment 5 to Rule 1.5, and it's there in the proposed opinion. But it basically says that once an agreement is reached, then it's the attorney's ethical obligation to fulfill that contract. An attorney can seek to renegotiate the fee agreement in light of changed circumstances. Circumstances could be a variety of things. The cases become much more complex, more involved. The economy has completely turned and everybody's rates are simply increasing. There's no specific language about what circumstances warrant a change. It's just that circumstances can change and there could be good cause for increasing the rate, but that is something that is left to the attorney to renegotiate the fee agreement with the client, and that essentially the attorney cannot abandon or threaten to abandon the client just to cut the attorney's losses or to coerce an additional fee. That is not in the model rules. The model rules do not have that language. The model rules are kind of silent to that. It's just kind of that, any sort of increase must be reasonable if there is an increase. So all that's to say, I don't know. I point that out because I know I've had conversations with some lawyers, some law students who have seen the model rules and they haven't really looked specifically at our rules and the language in our Rule 1.5 that really, I would say, would I guess in my interpretation, say that the just kind of very broad sweeping, we can change our rate whenever we want to, and you're just going to find out after it's happened, query whether that is permissible under North Carolina's Rule 1.5, even if it may be more permissible under the model rules. But that's really the crux of the question. Can a law firm or a lawyer have a clause of that nature in their fee agreement with the client? And if they're not allowed to, is there some type of clause that's permitted? And that's where you get into the proposed opinion which I sent out. Of course, it was in the October materials and sent out again today. That the proposed opinion basically says that no, a lawyer can't just increase the billing rate under the fee agreement that was described under that type of clause, but and they can't really just withdraw if they decide to say, hey, I want to charge $100 more per hour, and the client's refusing. You've already got that fee agreement. I think our Rule 1.5 says that you can't just abandon or threaten to abandon just to coerce a higher fee agreement, but that there may be some type of clause, and that's where you get into inquiry and opinion number 4 in the proposed opinion that talks about, maybe there's some sort of limit, or at least there's some sort of descriptive prediction. In inquiry number 4, there's a proposal that the fee agreement has this clause about rates may be increased, but they will not be increased more than annually and no greater than 3%. And would that be something that's permissible? The opinion says yes, that's okay, because that is going to be something that you've communicated to the client and it's not clearly excessive. So I think that's the thing that we need to flush out here first, is that type of very kind of broad, we can change it when we want and however we want, and you're just going to be on the hook. Is that permissible? If it's not, is there something that is? And that's where the proposed opinion tries to answer that question. Yeah, there is a way you can do this, because the reality of practice is that rates need to increase from time to time. But again, prioritizing kind of the client's interests and communication and transparency. That's where the opinion tries to come out with some type of solution. So I want to hear your thoughts. I want to hear what everybody thinks of this.
So
Yes.
if I can go first. Okay.
Oh.
So for those of y'all who don't know me, I'm Lori Vitale. Heidi, of course, knows me. So I'm okay with billing rates changing. And I think that it's something I noticed this was a family law case or family law inquiry.
I believe so, yes.
Sometimes we have our clients for years and years, and so it would be appropriate for the rates to increase. I don't think that it should just show up on a bill. I know with my practice, I send out notice of rate increases in November for the following year, so that if a client decides that there needs to be a change in an attorney or a discussion or has some objection, they have time to voice that and time to make changes. I haven't ever had anybody complain about the rate increase, but I also don't increase my rate in an offensive or surprising manner. But we do that annually. I think that annually is a reasonable amount of time. We don't always increase, but if we do, we give notice in November. But I don't know that that's something that needs to be stated in a rule or in a comment, that it should only be done annually. I think that's kind of micromanaging lawyers. And sometimes people, particularly flat fee people, and I know this is more about hourly rates, but I think that if rates go up for filing fees, for divorces or for motions or something like that, our cost to the passed on to the client is going to increase as a result of that. And if we charge a flat fee for something, it may go up as a result of that. And that may be something that's a mid-year increase. So I also don't think we should be necessarily setting an amount that would be an appropriate amount. I saw in here an inquiry for 3%. When I saw that, I thought, well, we shouldn't be setting what that percentage is, in part because I think it almost would read that anything above 3% might be considered excessive. I also saw in the model rules that they talked about, I want to say 6 to 10% or 8 to 10%. And I had written down here my comment when I read this, when I saw 3%, I said, how about 10%? But my first reaction is, um, it may not be the best idea to put in a specific percentage amount that I think you kind of know. It's like porn, you kind of know clearly excessive when you see it. So I think the two things that I took away and that I didn't like from the scenario that was presented was that it was automatically imposed without giving client a notice in advance as to what that fee increase would be, so that they could have a voice in that ahead of time. And I want to say it was it 20%, or did I get that from somewhere else? I did think that.
It was 20%, which I think is
Yeah,
probably.
and I think that's, that to me, unless there was some really good circumstance, that to me seems like, and it's excessive, particularly if they went back and did the same thing the next year. Because and I think they did come back and do it in the same manner. Yeah, the bill, I'd highlighted that the bill contained a 20% increase in the billing rate. And that's a lot. So that's it.
So I get the point of, I see how you got to the answer of no. I don't know that I agree with it, but I think it's also very circumstantial, Brian. Like I think about, what does the fee agreement specifically say? Like what I was just doing was going back and reading sort of what our engagement letters say. And they all, I mean, we have an addendum that we attach to our engagement letter that's more generally sort of our fees, our practices, withdrawing, terminating representation, social media, all the things that the state bar tells you to cover. But, in the body of the agreement, it says this is what our hourly rates are. We typically, review them every year, et cetera. And as I get later into the year, usually when we make a decision as a firm, what everybody's new hourly rate is going to be, which typically happens in November, we'll start adding language for new clients then that says it will be increasing in January to XYZ. But at some point, so I think part of the problem here, probably with the grievance committee, was really caught their eye, was Lori's point about the 20%. That's a lot. I mean, I get it. And I get you can't charge excessive fees. You have, signed a contract, but I think every contract is different. And where we need to give guidance is what is and is not acceptable. Now, I'm not sure about the impact of the comment. I know I should know. I don't. I'm sorry. I don't know if the comment can be amended. But at some point, I also feel it's incumbent upon the client, read your engagement letter. If there is notice, if you are put on notice that there is likely to be an increase, I mean, you've read it, you've signed it, you've agreed to it. And so ask, be proactive in your own representation. Lori, I didn't, she says she sends out a notice. That does make sense. Our practice is very much a volume practice, and by our, I mean domestic lawyers, much like criminal lawyers, unlike transactional lawyers who have like one client and it's Pepsi, so they don't have as many people to send the notice out, and that's probably good guidance. But if you've covered it on the front end in your engagement letter, they're presumed to have read it, they've signed it, it says we go up annually. I'm really struggling with the concept of an unsuspecting client who had no clue this might happen and then gets whacked with a 20% increase. And I see the problem in that. But I think we've all really tried to take into consideration state bar guidance on engagement letters and making those thorough. And so I feel like there has to be a better way than just no. I mean, I think these facts are bad because of the 20%, but I don't think just no is the right answer automatically. Now, I don't have the right answer yet, but I'm just kind of floating ideas of things that are worth considering. Um,
Yeah,
so
I agree. If the question is, may lawyer increase the hourly rate billed to client per the fee agreement? I think it would say it depends on what the agreement says. If the agreement provides for it, yes. But they have a duty for that fee increase not to be excessive.
right, it has to be reasonable. But there's got to be some obligation on the client who signed this, who sought you out, who, you know, presumably read it. I'm not positive they all do that, so I'm not naive, but if your agreement says we raise rates annually, you know,
And I think that was some of the comments that I heard from the grievance side and that I experienced too when I was doing grievances. You've got complainants that were just like, I didn't think this was right. And, did you read the fee agreement? Well, I went over it, but I went over it with my lawyer. I kind of felt like I had to because I needed representation. I just had to sign it. They felt some sort of coercion as much as and I think that's the thing that's always hard for me to gauge, the power dynamic in an attorney-client relationship. How much does our presence and our, like, this is how we're going to do this, it's not intentionally coercive, but to an ordinary person, does it feel forced? They just have to agree with it and they can't fight back against something. I don't know. But it doesn't, to your point, Heidi, it doesn't relieve them of their responsibility to protect themselves. That was where I saw the two things, that the high increase, and Lori, to your point, I get it. And I will say I intentionally put the 3% just to see, like, where are we? Because I think I personally agree. This notion of like 20% is too much. 3% is probably not realistic. It's probably going to need to be more than 3%. But do you find a number, or do we need to avoid the number and leave it to the lovely, lawyerly, it just can't be clearly excessive? Because clearly excessive, it depends upon the circumstances. So maybe it needs to be there. But the notice aspect is the other one that I get kind of torn on, because I think that was the other part of some of the folks in the Office of Counsel that had told me about some of the conversation, that just it being kind of like, oh, this is on your bill and it's already been imposed. The past month was charged at this higher rate and you didn't even know it. And so now you have to choose, either you pay the bill or you go ahead and find a new lawyer. I think that notion of being able to withdraw, people have asked me before, can I withdraw because my client is refusing to pay my invoice? Yeah, you can. They're failing to fulfill an obligation under their agreement. And that kind of butts heads eventually with like a fee increase or a rate increase, because no, lawyers aren't supposed to abandon their clients just to kind of coerce a higher fee. But at the same time, if there's some notice that it's going to increase, and then like you said, Lori, it sounds like you all give notice of the increase so before it takes effect. So it's kind of like, the client is aware, client gets a chance to say, hey, I need to talk to you about this. Or I need to find new counsel, and I've been given at least a 30-day head start. I feel like that's a very reasonable thing that you all do. And that would be one of those where the provision under 1.16 for lawyers that need to withdraw, they're allowed to withdraw when the client fails to fulfill an obligation of the agreement or the representation, especially when the client has been notified that the lawyer will withdraw. It's this transparency. It's the client, I'm giving you the heads up. I'm not just kind of, here's a bill, I've charged you a higher rate, you don't like it, I'm out and you're on your own. There's a little more obligation, I think, in the rules, but it's not, I don't know, it's not the thing that you are shackled to a client forever. If you're 5 years down the road and you've got an increased rate for everyone else, there's got to be some sort of reasonable kind of middle ground there. But where the middle ground is, well, that's where I'm looking to you, wise folks.
Well, I'll say that I agree with Heidi and Lori's their comments about this, except that I think we have to approach this without regard to what the number is. I think that it helped to read this. and to have the parameters between 20 and 3%, that made it very easy to say, yeah, that I can see how you came down this way. But I think what we end up with probably can't be quantified that way. It's probably got to be a lot more open-ended. But I feel the same way. And I think the thing that there were two things about it that concerned me. And one of them was the idea that and this was one of the alternative hypotheticals, I think it was number 3, that the client is notified 30 days in advance of the imposition of the specific amount of the increase. If the agreement said that that's what they would do and they complied with it, I don't see why that wouldn't be permissible. So I feel like that may have to be massaged a little bit. And the other thing I'm having trouble, and I don't have a solution to this, but the thing that concerned me a bit was the idea about not, if you can't reach an agreement with a client, being allowed to withdraw, but you can't coerce them. Well, I mean, if you can negotiate the fee, how much is too much in terms of I mean, I think you have to say either, well, we need to reach an agreement because we said we would in our fee agreement, and if we can't reach an agreement, we'll have to make a change. Isn't that threatening to withdraw? I'm not sure how to attack that part of it.
I agree, John. I find that part kind of tough because you have the clear language in the comment, but the thought in Rule 116 is that yes, lawyers can withdraw, and that's the tension. So, yeah, is notice enough? I know the inquiry number 3 talked about 30 days notice, and I drafted it saying no because the comment kind of concludes one thing, but personally, I have different feelings. So that's where you're sitting here using what you got right in the rules, and I don't know if that is something that we feel differently about the comment, the language in the comment, or maybe there's just something like you said we can massage this particular inquiry a little bit because it does need to be reasonable. It's just it's not. I don't think it's a reasonable thing to say a lawyer, you struck a bargain with a client, and that case ended up taking 3 years more than you thought it was going to take, and everything increases. Your rate has gone up. Are you stuck with that old rate for 3 years, kind of regardless of what's happening in the world around you? And just the fact that you've given them notice, even if you gave them 6 months notice, I'm planning to increase my rate in 6 months. Otherwise, I'm withdrawing. Is that coercion? And I don't think it is. But I think that might be something that we need to flush out.
But what about if you've got notice in your fee agreement to start with that we do this annually? Like there is notice there. And maybe not the specific notice of what it's going to be, but at that point they're on notice that this is an annual thing. So I think there are two questions. There's the question of reasonableness, and it was interesting to read that the ABA seemed to focus much more on the question of whether or not the increase was reasonable.
Yeah.
And I actually preferred that focus. I mean, I thought our comment was a little bit, what's the word? Well, I'll think of it, but what? Petty. I mean,
Petty.
narrowing, it was, choking. I don't know. So, I think the notice needs to be addressed. I think the reasonableness needs to be addressed. But, in that particular, the one we're talking about, it did say, where'd it go? That, hey, we're going to go up, maybe increased at least once each calendar year.
Well, one of the concerns in the hypothetical, the facts in inquiry 1, you're right. It did say that that we review them every year and there may be increased, but it says you'll be notified on the statement when the rate change occurs. That's a problem.
Agree.
The advance notice, I think we all agree, at least the ones who've spoken up so far, I think we all agree that giving advance notice of at least 30 days that this is what we're going to do, and saying that you're going to do just that in the contract, I don't see a problem with that. I also wouldn't see a problem with it if you, in the agreement, if you had a specific amount that it's likely to increase by, or a limit of what it might increase by. I mean, if you put in, they'll increase, but it won't be by more than 10%, without your consent. I mean, if you said something like that and you did it 5% every year, I don't see how the client could complain, as long as you told them in advance and they had the opportunity to know that it was going to be done before they actually got billed that. I have no qualms about any of those things, but I think the problem is when it was done almost automatically. And I think that's also why the draft opinion has the whole thing about, it says that, we'll give you notice, and if you don't, of an unspecified amount, but if we make an increase and we give you notice and you don't object to it, you've agreed. Well, that's sometimes the way contracts work. But that's a little more difficult to impose on a client given the nature of our relationship with them. So I see that might be somewhat problematic, although I think as a practical matter, it's probably something that happens in other settings. But I think the idea of advance notice, having it in the agreement, saying that you'll do it with advance notice, given the advance notice, and then making sure that whatever the increase is reasonable, all of those need to be part of the solution here.
Well, I'm
I
curious
agree.
for everybody, and Takia, when you were in private practice, and Davis, I mean, how many have y'all ever had an issue with this?
No, most of my cases were flat rates.
Oh, that's right.
So,
Oh, criminal.
I did do some hourly work, but if I did, it didn't last, long enough for me to have to increase my rate. And so, I mean, I get that, there are cases and there are, lawyers who have cases that last years and years and years. And so it makes sense and so my whole issue was the notice. As long as you can provide that appropriate and adequate notice, I don't see why there's a reason. And of course, with the fee being reasonable, like I don't see that there should be an issue as with doing that. I think like John that he had made a good point. You have it in your retainer, you send out a notice, 30 days before, or if you say it's capped at 10%, may go up to 10% or whatever. I just think the biggest thing is the notice issue. Because if you notify somebody of something, that's what it is.
Right. And
But
then
then
at
at
least
some
they can make an
point,
informed decision, right?
they can
About
make
what
an
they want to do.
informed decision about whether they want to continue with you or if they want to see if they can find somebody cheaper. Like that's just, what it is. But the notice, as long as they have notice and it's, like I said, appropriate and adequate, I don't see the issue.
Yeah, I think with notice, I think that John kind of hit it on the head. It could be an either or scenario where, hey, my fee agreement says that my rates are going to increase not to exceed this percentage. And that way it's in there, this percentage. So in this guy's, if you just say it could increase, I think you have to follow that up with like a 30-day notice about how much it's going to increase if you don't
Right.
specify some sort of percentage or not to exceed amount. And I think that would alleviate a lot of the concerns with notice. The question is, as a subcommittee, or as the state bar, do we want to try to control and set a rate for reasonableness? That's something we need to
Right.
decide.
That's-
And, if we come out with an opinion, is it even enforceable if we just say, it can't be clearly excessive. So somebody then goes up 20%, will they get, prosecuted for it in a grievance scenario? And what if it's only 17% or 16%? At one point, who makes that decision? I guess
Right.
It's
that's
arbitrary.
Right.
that's an issue.
Yeah, and I'll offer one thing as a staff member. I would love if we didn't have a specific number. That's going to be real tough. And I think to Lori's first point, we don't need to micromanage attorneys. There's a lot of independent judgment that needs to be exercised here. And so I think I'm hearing what we're saying, and I want to rewrite the opinion to really flush out this idea of notice, that if you do have some specific terms in your fee agreement that provides the client, again, to me, I do think it goes back to, does the client know what's going to happen?
Yeah.
Does the client know what's
Right.
going to happen, and do they have the opportunity to potentially go in a different direction? So if you get in your fee agreement some type of specific term that says it's going to increase no more than annually, or at least annually, whatever it is, but it's going to be capped at such and such amount. I think that is sufficient notice of the specific parameters of the fee agreement. You have communicated the basis or rate of the fee to your client, which is what we're required to do. If you don't have that specific language, then I think before any sort of fee increase occurs, I think it's a reasonable thing to say, give the client some notice of what's about to happen. You can't do it in a way that's going to be clearly excessive. What's clearly excessive is going to be dependent upon the circumstances. So that is going to be something that will need to be evaluated case by case. And I know that's something that, as a former Office of Counsel attorney, I really disliked those sorts of answers, but that is the correct answer. I mean, it has to be. So, so yes, I think we can put that in there. And I'm hearing that we don't want to set any sort of, this is reasonable, whether it's an increase of X amount percentage, we're just going to stick with the clearly excessive.
I think so. It's just
Yeah,
too
I think-
unpredictable. I mean, we had a
Yeah, I think-
CPI increase during COVID of 11% one year.
Yeah.
And I mean, that was unprecedented in my time, but that can happen. And, if I were to say 11% was excessive, it wasn't that year. So I don't know, but I think the notice to the client is two things. Notice in the agreement that it's a prospect, and notice of the increase before it's imposed. I think that's a two-pronged
I
notice
agree.
requirement that we all agree is the minimum amount of fairness, that we need to have. And also is going to make it a lot harder for a client to really justify an objection if they've agreed the first time, and then they have an opportunity to have input onto the proposed increase when we actually impose it.
Do we agree though that if it's stated in the original contract, you don't have to follow up with a second notice if it's stated how much and it can be, or do you still think even say, all right, we can increase our rates up to 5% annually in the agreement, the original agreement? Do you need to send them another notice out 30 days before you actually do it?
Right,
I don't-
because I didn't know
probably
that we
would.
were
I-
agreeing
I mean,
to
that's,
second
But
notice.
that's my question. That's what
Yeah.
Heidi did. What I
Yeah.
can tell that's not what Heidi was doing,
I
and
think
so
that's
but it
sufficient
does.
notice.
Okay.
I think that
Is that
if you're
sufficient
giving,
notice?
I think that is the notice that it's going to go up every January, or, once a year in January. It doesn't even have to specify January, but annually it goes up not to exceed 5% or 10%. I think that's notice enough.
Yeah, I agree. And I think with notice, obviously, the whole thing, the whole issue with notice is to avoid the other situation that we have here where you're threatening to abandon the client. Like it gets that up, if a client doesn't take notice of it and do their part to say, hey, wait a minute, you sent me notice that this is about to happen. I don't agree with this. Let's talk about it. Then when it happens, you've got to, you're not necessarily abandoning them at that point.
Right.
And you're coercing them. You're not coercing them, but
Yeah, I guess
How's
I
that
would,
out,
I would be
David?
the
When it-
outlier. I would still send notice, but that's just me because
Well, I mean,
I know
think
how
that's
people
just
are.
Best practice.
Instructional
Yeah.
guidance, but I mean, I don't feel like, you can say best practices are,
Well,
but
yeah,
The best
yeah.
practice would be to send notice, but
Right.
are you ethically obligated to when the contract's when the contract's clear?
yeah, and you're on the hot seat with the grievance committee when you've made it clear in your agreement, this is gonna happen. I mean,
Right.
you're
Well,
right
how
about
about-
best practices, Takia, for sure, but
Yeah.
Yeah.
I mean,
I could
Who's
include, well, you tell me. I mean, y'all are the ones that are out there in the trenches, and when an ethics opinion comes out that says this is the floor, this is the minimum thing you need to do, but certainly would encourage lawyers to consider doing this extra best practice thing. Does that come across as helpful, or does that come across as the bar is basically saying if I don't do this best practice, then I'm violating the rules, even though they've already set the floor? They said I don't have to. They just said
Well,
they
I don't think
encourage me.
I don't think it would be seen as a violation. I think that
Right.
it's kind of a clue to those of us who are practicing that, look, if you have a question about whether or not your contract gave adequate notice, go ahead and send out a notice 30, 60 days in advance.
Mhm.
But if you don't, it doesn't mean you violated an ethics rule.
Right. Right.
I think all of our billing inquiries this is the second one I've been involved in, the double billing one as well, and that it's always two-pronged. It's notice and clearly excessiveness.
Yeah.
And so I think that, as long as we're supporting those two premises, I think we're good. One question I had for the group is, given the exact inquiry that we've been given to kind of digest, do we want to say 20% is clearly excessive as a subcommittee? Do we want to? We're not saying what is what's reasonable, but do we want to say that's excessive?
I think we should stick to say it may be excessive. It is, we might even say it's likely excessive, but I think it really depends on the circumstances.
Right. I don't think we have enough information to determine whether it's
Yeah.
excessive or not.
Well, and I know that, like, for example, we've had an associate who I think has had an underbilled rate for a while. And finally I was like, we got to catch you up. And, we sent out notice and it's all in the engagement letter, but it probably hovered close to 20% just because
Yeah.
it was too low to start with.
Yeah.
And it's still low probably. So I think it depends on the circumstances, Davis, to answer your question. 20% of 1,000, 20% of 200, I
Right.
mean,
Yeah, I agree. I think we need to steer away from specific quantification because there's so
Yeah.
many factors that can play into it. What if you charge one rate because you thought the case was going to be in a civil district court? The next thing you know, something's happened, the case has changed, and now it's been removed to federal court. I mean, the circumstances like that may be something that some people would agree change the real nature of what you're doing.
Yeah.
Right.
I will also say from my conversation with folks in the Office of Counsel that were working on this matter, I think the notice thing was the one that got them the most. The amount, it's kind of. I mean, I didn't think that we were going to be quoting Justice Potter Stewart in this meeting. Lori went ahead and did
when you
it.
see
That was
it.
Lori.
You know it when you see it, and I think that number when they were looking at that particular file was one that they didn't have as much heartburn trying to make a call on that. It was the notice of like kind of this very vague notice in the agreement, and then suddenly, oh, it's been imposed, and I owe a month's worth of work at this higher rate. Had no idea that was coming. So this would answer the question very well, I think, for grievance, and they'll apply. We're going to call it the Lori Vitale rule. You know it when you see it. That's clearly excessive.
No, do we know it when we see it? Wasn't there that opinion, Lori, out there maybe 20 years ago where Deal charged like $100,000 non-refundable retainer?
Mhm.
And like
I
that
think it
passed
was like-
muster.
It was because, according to the opinion, it was because he charges that non-refundable retainer because everyone knows he's the meanest son of a bitch there is.
Well, exactly.
And
I'm like,
engaging him is worth that much.
I still
Yeah, I
find
don't
that
think it was
opinion
that
outrageous.
much by any means,
It was
but it was,
$25,000
it was a high retainer, and you know what?
And
I don't think
non-refundable.
he won that issue, and because people would go to conflict him out. So he'd
Yeah.
say, you need to pay me a big retainer if you want to be able to conflict me out, which is,
It's good
Yeah.
work if you can get it.
They're on notice. It's non-refundable. So if you don't like it, too bad. So sad.
Yeah, I mean, I think
Takia's
that
like-
Brian ultimately chose to use somebody else. It might have been 25,000, I think it was.
Yeah. So I was
Yeah.
thinking.
But it was, that was a unique situation. But again, I think that's why we can't set a specific amount or percentage
Yeah.
because there are going to be those circumstances that it would merit that fee, or it wouldn't be excessive or offensive.
I was just looking at Takia's face when we're talking about that. She's like, I don't need to be on the bench anymore. If I can go
Right. If
throw
I
out a
can get
25,000 retainer.
25,000,
Non-refundable.
$50,000 non-refundable retainer.
Non-refundable.
Yeah.
Yeah.
Almighty.
Non-refundable.
All right. Well, I'm going to amend the opinion, and then
We need you to get to yes, Brian.
yeah, I'll amend the opinion in a way that reflects our conversation, and then I will ship this off into good hands when I go decide to open up my own practice and start charging $25,000 non-refundable retainers.
Brian, can I ask you a question about amending this? Does that mean you're going to change the questions, or you're going to amend the answers and not change the questions?
You know, it's probably going to be a little bit of both. I want to make sure that we are, because this is just the first draft. Everything
Right.
is eligible for redrafting. So I'm kind of taking the principles that we've discussed here, and I'll craft this in a way that answers the question clearly, but also, you know, offers that hopefully helpful guidance for lawyers as they're going forward and saying, okay, so what exactly can I do? And maybe there's going to be those points where, like we said, you know, we might not be able to put a particular number on it, but that's an opportunity where hopefully the lawyers that read that, and if they say, well, I do have a question, call for ethics advice. We can talk about it. We can talk about your specific circumstances and your specific facts and things of that nature. So, yeah, I'll rewrite this, and I'm going to send this around. It's definitely not going to be ready for next week, but yeah, I know Heidi's very surprised. But we'll have this thing ready. I think it'll be ready for publication for the April meeting for sure.
Perfect.
Very good.
All right.
Thank you.
Right.
Oh, thank y'all. I have to say so like whenever I draft an opinion, I have one of two goals in mind. Either one, it's just right, or two, I know it's going to subcommittee because it's a hard issue and it at least gets the conversation going where we get to the right place. That's what I was hoping with this one, and I feel like we are heading in the right direction. So
Have pretty much consensus here, so that's
yeah,
good.
mission
Yeah.
accomplished, team.
Anything exciting next week for us to talk about on Thursday?
I
Anything
mean,
worth coming?
It's our conversation here, probably.
yeah. This is the most exciting thing right here. No, I'm kidding.
Well, money, right?
Yeah. No, we have a pretty straightforward agenda for next week. So I don't think it's gonna be a terribly long or very debated sort of meeting. But we'll see.
You and Lori got to get out of town.
Yeah. We're gonna see if we even meet if the weather forecast of 15 inches of snow is correct, which I don't think it is.
Oh, true.
Well, she and I are supposed to be going to Boone for a meeting, so
Oh,
stay
wow.
I may
tuned.
have to ride with you. Although I think my car's got better tires. You may be riding with me.
Girl, you are underestimating McCon.
Can I ask about that? Because that's not come up since I've been on the council where we've had actually a weather issue.
Yeah.
If there is, you know, what are we likely to get? I mean, if y'all foresee a real likelihood of treacherous conditions, are we likely to get notice in advance of Tuesday or Wednesday?
Yeah.
How does
So
it usually work?
yeah, Peter and I were talking about this yesterday. We're basically going to keep an eye on the weather. It's, you know, everything changes, but I feel like, you know, when you get 3 days out, usually you know. So hopefully around Sunday we'll have a good indication of what's really coming. If it's really looking like a big storm, then, you know, the nice thing that we learned during COVID is that we can convert things to
Virtually.
virtual.
Because I think the
Yeah.
last time this happened, Brian, was pre-COVID. It was like 2018, maybe.
Yeah, and a lot of some people got stuck, you know,
Yep.
or some
Yep.
people had to leave very early, like they left on Thursday morning because they
Because
needed to
it
get back
came
to
in
the
on
mountains.
Thursday night and Friday.
Yeah.
Mm.
So we're just gonna have to see where it's going. I mean, last week's storm, I mean, different
you
parts of the
calling it
triangle
that?
hit it, but it wasn't. I don't know. In my part of the neighborhood, it was completely dry. So you just never know. But we're going to keep an eye on it and let everybody know if it really looks dangerous for folks to come in here or that we would all get stuck in here, then virtual very well may be an option.
Okay.
Yeah.
Very good.
Perfect.
All right. Well, thank you, everyone.
Thanks,
Thank you for your time.
Thanks,
Thanks,
guys.
All right.
next
Hopefully see you next week.
See you next week,
Hopefully.
maybe.